Hello, welcome to the Empower Series Online. My name is Clifton Johnson. I'm the founder of the Empower Series Incorporated, which is a 501c3 nonprofit organization brought to you by the generous donations of Comerica Bank, AE Media Group, and you, our viewers in the United States and around the world. So thank you. You want to find out more about the Empower Series? Definitely check us out on social media. We're on everything. We're on Facebook, Instagram, Twitter, LinkedIn. You're on YouTube right now, so definitely like us, share us, provide comments. If you haven't subscribed, subscribe and hit the little bell to notify you when we upload our videos. And most importantly, you have to share us with other people. The only way people are going to find out about the Empower Series is if you empower them and share us. So please do that. Check us out on our website, www.empowerseries.com. You're looking at that on the screen right now. You can see our different programs, how we deliver hope, inspiration, education, and connecting you to resources to help you take that next step to achieve your goal. If you want to make a donation, you can click the top left-hand corner of the donate button there and make a donation. You can also text give or donate to 214-225-6337. It's on the screen right now. So you can text give or donate to 214-225-6337. You'll be directed to a secure website and make your donation. If you choose to do so, we greatly appreciate that. Now, our topic today is going to be on estate planning because October is the month for National Estate Planning Awareness Month. So what does that mean? We want to increase the awareness of the importance of estate planning. So people don't like talking about estate planning, but with COVID happening now, people are more interested in it. At the end of the day, estate planning is not just for October, it's for every day, because at some point, it is guaranteed that we're not going to wake up one day. And we want to make sure that our loved ones are properly taken care of and they don't have to figure out all of this mess when they're grieving our loss. So what we want to do in this program is definitely give you the basics of understanding what estate planning is, the documents of estate planning, and really encourage you to take that next step of seeking information and preferably working with a professional to get your estate plan in order for your loved ones. Our guest today is a recurring Empower Series speaker. He is involved in the community. His name is Attorney Kenneth Walker. He is a partner in the law firm of Walker and Chambers and a member of the J. L. Turner Legal Association. Kenneth practices in the areas of business law, computer law, taxes, and estate planning, including wills, trust, and probate. His hometown is Memphis, Tennessee, and he's received a JD from Harvard Law School and a BA in Economics and Afro-American Studies from Harvard College. So Kenneth Walker, brother, thank you for spending a portion of your life to pour into the Empower Series again.
Thank you, Clifton. It's a pleasure to be with you once again.
And before we dive into what we're going to talk about today, I want to make sure that since we're talking about legal matters, that on the screen right now is going to be a disclosure of what we'll actually cover. So I'm going to go through and read this, and then if you want to, you can add to it, or maybe this disclosure is going to be sufficient. The information provided in this program and below the video in the description section of this YouTube channel do not and is not intended to constitute legal advice. Instead, all information, content, and materials available on this program and this YouTube channel are for general informational purposes only. It may not constitute the most up-to-date legal or other information. The links to other third-party websites are only for the convenience of the reader, user, or browser. You should contact an attorney to obtain advice with respect to any legal matter. No one should act or refrain from acting based on information shared without first seeking legal advice from counsel in the relevant jurisdiction. Only your individual attorney can provide assurances that the information contained herein and your interpretation of it is applicable and appropriate for your situation. Do you want to add anything to that, Mr. Kenneth Walker?
There's nothing I can add to that.
Well, I think it's also interesting with this COVID and how it's affected the way we operate. You would think that more people would now want to get their estate plan together and get it in order, wouldn't you think?
Actually, Clifton, since we last spoke, March of 2020, my busiest area of practice has been in the estate planning and probate area. Unfortunately, people seem to have and more sensitivity and a higher sense of motivation to get those things done. Yeah.
Yeah. So the 2022 study shows that 1 in 3 Americans who have no will or living trust claim that they don't have enough assets to do one. So there's still this misconception that a will and estate plan is for people who are wealthy, and that's not really true. Americans who have had a serious case of COVID-19 are 99% more likely to have a will than those who have not. And so that's the uptick that you're experiencing.
Yes.
I think since the beginning of the pandemic, another statistic is that the number of 18 to 34-year-olds with estate plan documents have increased by 50%. Another thing that you're experiencing. Also, estate planning activity has largely decreased, unfortunately, over the past decade or so, dropping from more than 50% of Americans having a will in 2005 to roughly only 30% having a will today. Additionally, many Americans don't openly talk about their estate plans, which is unfortunate. So there's a lot more statistics that's out there on the screen, but those are just a few of them. And what we plan on doing on this program is really squashing some of the myths that are out there about that and clarifying what the estate planning process is, what the documents are, and then more importantly, connecting them to resources and encouraging people to have those conversations, not only with their families, but also with professionals. So in your experience, when someone's coming in to meet with you for a lot of different reasons, do you kind of have to step back and talk about what is estate planning before you get into the details of what they want? How do you really approach it and introduce that conversation to your clients who are coming in to meet with you?
Most people who contact us are motivated by something in particular, and either someone has died or somebody they anticipate a death, or it's something they've been just putting off for a very long time and they know it's overdue. So they're motivated usually if they make a call to our office. And so the first phase of our representation starts with getting a comprehensive understanding of them, their assets, and their family situation. And so after we gather that information, then we are ready to have an initial consultation, including our recommendations.
Okay, so that leads me to my first question. And what we're going to do is there's a list of questions on the screen right now of what we're going to cover. And so one of the first questions is what makes up an estate?
Okay, that's a very good a very good question. And from an estate planning attorney's perspective, when we generally talk about an estate, we are generally talking about a probate estate, which is what you own at the time of your death. Anything that you own, any property that you own, anything that you own an interest in as of date of death. That's the probate estate. There are other assets that are not covered by the probate estate. They're called non-probate assets. And those are things like life insurance. Those are contracts that designate beneficiaries, and that passes outside of the legal probate process. Mm-hmm. And then you have some people, very few, who have what's called a taxable estate. And that's someone, a very wealthy person who has assets at the time of death valued at a little more than $12 million as of 2022. The number varies depending on what the date of death is or the year of death. And so generally, when we're talking about an estate, we're talking about the probate estate that needs to go through the probate process.
Okay, so one thing is to get very clear on their probate assets, then there's non-probate assets, and then there's is it estate taxable assets? Is that what we're describing?
If you have a large enough estate, 12 million plus as of 2022, then you fall into that taxable category. So the vast majority of people do not have to worry about the taxable estate, okay? Very few people do. Ordinary people have to worry about their probate estate because all of us own something at the time of our death, even if it's just the clothes on our back. And then many of us, probably most of us, have some type of life insurance. We may have retirement and pension plans and things like that where you designate a beneficiary. Anything you designate a beneficiary on, that is going to pass outside of the legal probate process.
So let's talk about that. So basically, most people have a checking account and a savings account. So those are assets that might be owned at the point of passing. But then if you have a beneficiary that's designated, then the transfer of those assets is going to happen outside of the estate and outside of probate. But are the checking accounts and savings accounts identified as probatable assets, or are they not?
If they have a beneficiary designation on them, they pass outside of probate. They are non-probate assets. Okay.
But then the only time
if they don't, then they are probate assets. And for most people, they don't have beneficiary designations on those accounts, and they wind up being probate assets.
Right. Okay. So that's a good point to make, that they don't have to be, but it depends on you going on and making sure that every account, whether it's an investment account or a bank account, has a beneficiary designated so that it doesn't have to go through probate unless you intentionally want it to, right?
Yeah. Yes. And, and it depends on the financial institution that you are doing business with. And it also depends on the type of account that you have with that institution as to whether or not beneficiary designation is even possible.
Okay. So before we get into what probate is, let's talk about the whole statistic that 1 out of 3 Americans think that they don't need estate planning, or they don't need estate planning because they don't have a lot of assets. So who needs estate planning?
Okay. Let's deal with a very fundamental fact. Every human being will die. Okay. That's unavoidable. Death is certain. And at the point of death, you have an estate consisting of anything that you own at that time. And the confusion has come in, I think, in large part because of the word estate planning. Okay. Traditionally, wealthy people use that term to talk about their vast fortunes. Okay. But the reality is, if you die, you leave property and you leave loved ones behind. If you want to make sure that your loved ones are taken care of, at least to the extent you have anything that you want to go to them, then you take control of that process by taking care of your estate planning prior to death. Otherwise, whatever state you live in this case, the state of Texas has already written an estate plan for every person who dies in Texas. It's called the Texas Estates Code, and it's what people commonly understand as the intestacy laws. And so if you don't take care of that business by having your own estate plan, then the state of Texas says, this is what happens to your property after you die. These are the rules, whether it's good for your family or not. So everyone needs an estate plan if they want to be in control of their property and make sure it goes to the people to whom they intend those benefits to flow.
And that would be, so at the age of 18, that's the legal age that you can actually create a will. Is that correct?
Yeah, you have to be a full-grown adult. There are some technical exceptions like military and marriage and things like that, but we won't go into that. But as a general rule, you have to be a legal adult of sound mind in order to create a will and other estate planning documents.
Okay, so what I want to do now, as we talk about what a well-designed estate plan is really basic to understand the different documents of an estate plan. So, because it's more than just a will. A will is used after death, but estate planning is also really talking about what happens if you reach the state of incapacity or you're not able to function and take care of your health decisions or financial decisions before you pass. So let's kind of go through the documents that are contained in an estate plan and help us identify what those documents are and define them.
Yes, the cornerstone is the will. But before we get to the will, let's go back to a point that you raised. There are two situations that you're basically dealing with. You're dealing with what happens when I die, but you also need to deal with the situation of what happens if I'm physically or mentally incapacitated, because frequently, if people live long enough, many of us will, if even for a short period of time before we die, will become incapacitated. And God knows, it doesn't matter what age you are, you can also become permanently or temporarily incapacitated. So we have to deal with death and incapacity. So let's first talk about death. The basic instruments that you're talking about in the situation with death is the will first, and the will is designating an executor who's in charge of the process, the probate process. That's who you're going to designate to put in charge of the process, the legal process. It also will transfer any assets that remain that you haven't already perhaps transferred prior to death. So that's the will. It's the foundation. In addition to the will, you may want to also have a living trust or what's called a revocable trust in order to dispose of some assets prior to your death. Because the more of your business you take care of before you die, the less of a burden you leave on your family to take care of that business, and you save yourself some expense on the legal side of things. So you have the will as the foundation. You can add to that the revocable trust. The other thing that the trust can do that the will can't do is it can coordinate those probate and non-probate assets so that everything winds up flowing into one bucket, all to be administered by the trustee after death. Okay. In addition, go ahead.
Okay, so before we go any further, let's kind of talk about, define what a trust is and the different players of the trust, like the grantor, the trustee, the beneficiary, what is it called? Not necessarily the co-trustees, but the successor trustees. Who are the players in a trust?
Okay. The basic players in the trust are the person called the grantor or the settler, and those are fancy legal terms for, that's the person who's creating the trust, okay?
Okay.
So I'll use myself, for example. If I'm creating a trust for Clifton, I'm the grantor or the settler, I'm the person creating the trust. The other person in the trust relationship is the beneficiary. In this case, I'm creating this trust for Clifton. He's the beneficiary. And I want to make sure that Clifton gets the benefit of certain property that I'm going to put into this trust. But I may not want Clifton to manage or control that property. I want him to get the benefit of it. So I may want him to get income from it, but I don't want Clifton to control that property. And so I name another person as the trustee over that trust. And so even after I'm gone, that trustee is holding that property in trust for Clifton. Clifton's getting the benefit, but the trustee is in control of the management of the property. And the simplest example of something like that is in the case of a minor. If I have minor children that I want to make sure are taken care of after I'm gone, then I may designate, I'm not going to put that property in the hands of the minor. So I create a trust and I get a competent adult as the trustee, and they will be over that trust for as long as I have the trust run. It may only run until they become adults, or it may be for their lifetime or any other age that I choose, but they don't control. That trustee that I designate controls. And if something happens to that trustee, I can have, a fallback where I've already designated the successor if that person doesn't serve or refuses to serve or can't serve for whatever reason.
Okay, that's a great example. So also in a living trust, let's say in this situation, I want to create a living trust. I can be the grantor because I'm creating this trust. I can also be the beneficiary, and I can also be the trustee initially. And that's my living trust. And then if I become incapacitated, then my successor trustees can be the people that I designate to actually handle the assets in that trust for me as the beneficiary. And then I can also identify successor beneficiaries in the event that I pass away. So I use that as an example to say that a trust can be a complicated document, and it's very important to meet with a professional like yourself to really make sure that people understand what a trust is and all that it's capable of doing.
Yeah. Well, I said the will is the foundation document. Then you can also supplement that with the trust. But in addition to those documents, you've got to deal with the issue of incapacity as well. And in terms of incapacity, there are a number of documents that you want to have in place. You can designate a guardian for yourself in the event of your incapacity, so that you already know who will play that role if you become incapacitated. In addition, again, with children, if I'm a parent, I have small children. If I become incapacitated, I can designate somebody to be the guardian of my children in advance, rather than, have the court choose somebody that I may not ever want to be the guardian over me or my children. You also need an instrument for someone to manage your property and your finances in the event of incapacity. And a statutory durable power of attorney is the instrument that you can use for that. You want someone who can make medical decisions for you. And so a medical power of attorney is something that you use for that purpose. Then we get to those end of life decisions that become very hard and burdensome on families, where you have the issue of a loved one is on life support, and rather than have the family, under the stress of trying to do or guess or, argue or fight about what that person wants in that situation, you can have what's called a living will that you have created. It's also called a directive to physicians or an advance directive where you say what happens in those end of life decisions, like, do I stay on life support or do I not? Under what circumstances does that happen? You can take control of those types of decisions as well.
Okay, and I think it's also important to know that as you create these documents and you identify these agents that you want to be responsible as an executor or as an agent for your power of attorney or medical power of attorney, it's best to assign more than one. Because in a situation where they can't perform that role or they pass away before you, then it's good to already think about who the secondary or even the third person in line to perform those functions are. How many people do you normally recommend when you're doing these documents that people think of as the primary, secondary, or maybe the third agent to performing those roles?
I always advise people at least try to have one successor, at least one, because you never know what's going to happen in life. And then when you have situations where everybody involved is elderly or not in the best of health, you may want definitely to have multiple people that are younger to come behind that. So it really depends on your situation, but at least if it is possible, please always have at least one successor because you just don't know what's going to happen.
Well, I know you've been asked this question. What if, people look at their circle of friends, their family, and there is nobody in their right frame of mind that they would trust to be in this role? And I know you've had people like that, right?
I still have a client who came to me maybe more than 25 years ago and never finished his estate plan, he and his wife, because they couldn't decide who they wanted to designate as guardians of the children. And by now, the children are probably at least 40 years old. So it took care of itself.
Well, I'll tell you this, attorneys can do a lot, but they can't make certain decisions for people, right? You can't make decisions for your clients. So is there a way that you guide them through the process if they really are having a hard time selecting someone to perform in those roles? How do you assist them in lieu of just letting time run its course?
First, I try to unbundle the decisions, okay? Because a lot of times people think of, I got to have one or two people who can handle all of this. And that's part of the problem. I may have somebody who is great with money, but horrible with children. Or I may have somebody who's great at managing money, but I would never want them caring for me if I got ill. Okay.
Just put him in the corner. He'll be all right.
Right. I got the money, but just toss on the side. No. Okay. So you look for people based on skill sets first. Okay. Right. I need somebody who can not only manage money, but I trust. Okay. Because they have to be trustworthy. That's one box. I need somebody with a skill set as a caretaker. That's another box. And so you break it up that way. And a lot of times when we start breaking it apart, it starts to answer itself for people. And yeah, it sorts itself out. But yeah, at the end of the day, hopefully you have a broad enough range of relationships that you can trust somebody in that role. Otherwise, you're at the mercy of the court making those appointments if it comes to it.
Okay, so here's what I want to do. I would like you to talk about the probate process and what the executor, who's the main representative or agent in the will, what that person is responsible for doing, because they usually have to get an attorney to help guide them through the probate process. There's usually some cost involved in that. And sometimes when people are signing an executor, they're not informing that executor of all that's involved until after they pass away, and then they're learning about it. So explain that process to us. And then we're going to, after we talk about that, we'll talk about now, how do you get resources to assist people in the process if they don't really have a lot of wealth, a lot of money?
First of all, if you designate someone as an executor in your estate plan, or a successor, I always advise people, have a conversation with the people before you do that, to make sure that that's something that they're willing to do. Even though you think they're great, they just may not want to do it, okay? Because it is a lot of work. So have that conversation first, and then make sure you give them the name of the attorney who drafted the documents. You don't have to give them copies of your documents or anything. You may want to keep all that private, but at least give them the name of the attorney who drafted the documents, all right? And the first thing that they should do is contact that attorney. They should not start trying to take steps, because just designating somebody in a will doesn't make them legally the executor. They are just a designee until that will is filed with the probate court properly, an application is filed with the probate court properly, and the court appoints that person with a court order as the executor. That's when they actually have legal power. Just putting their name in a will doesn't give them legal power. So the first step is contact the attorney. And if you can't find the attorney who did the thing, then contact some attorney who practices in this area, so that they can guide you as the executor through the process.
Yeah, and we'll talk about where to go if you don't have an attorney to go to. But with that being said, so it sounds like in contacting this attorney, in order for you to be designated officially as the executor, there may be some court proceedings in place and some filing fees. There might be a cost involved to initiate the probate process. Is that correct?
There is a cost, because to file the application you're going to have to pay a filing fee with the court. Okay, so you've got to, at a minimum, do that. And at a minimum, you should get at least a consultation with an attorney before you try to prepare or file anything with the court, at a minimum.
So how much roughly in the state of Texas does that cost to initiate this probate process?
If you're trying to budget for a very efficient, low-cost probate, what I recommend to people is you have between $3,000 and $5,000 on hand. That's what you need at a minimum, in my opinion, in Texas. That's assuming you have a will and with an independent administration. You're going to need between $3,000 and $5,000 on hand for the legal fees and the court costs. And that also assumes that you're not involved in some contentious situation where you got people challenging the will and things like that.
Got it. So in addition to the executor going through this process, that executor, he or she, will be learning about what the responsibilities are of that role in taking a full inventory of all of the possessions and, reporting to the attorney in the court. So can you just summarize, what is the responsibility of the executor? What is entailed for them to do once they've been appointed by the court?
The executor if there's a will, or the administrator if there's not a will. Those people are the legal representatives that have the power and the responsibility to settle the estate. That includes identifying and inventorying all the property of the deceased and identifying outstanding debts that the deceased owed, settling the debts. You may have to collect some of the assets in order to be able to settle some of the debts, paying the expenses of the administration, and then after all that is done, making the distributions to the beneficiaries in the case of an independent administration, or the heirs in the case of a dependent administration.
All right, so here's what I want to talk about, because when people are hearing this now, they're probably thinking, if they don't have a lot of money, that's not going to make a lot of sense for them. So I want to talk about two pathways. One pathway is, instead of getting your documents together and then realizing that if you have a will, your surviving family or friends will have to go through a legal process that will be costly and timely. The other alternative is getting what we talked about earlier, a living trust in place and handling some of the transfer of the assets prior to death, so that you can hopefully mitigate, or if not eliminate, the need for probate completely. Do you talk to your clients about that option as well?
Oh, absolutely, because there's one very simple way of pre-funding the cost of the probate. And that is, if you have a living trust set up already and you designate that trust as a beneficiary of, let's say you have more than one life insurance policy, right? And you have a small policy. You have those proceeds go straight into the trust at the time of death. And so that's just the insurance company cutting a check. And then if you got your trust and your will coordinated, the trustee could use those proceeds from the trust to pay for the expenses of probate and give those to the executor to pay for the filing fees, the attorney fees, and things of that nature. So yes, those are the types of practical things we also discuss. Yes. Which
is important to really sit down and talk to, in my opinion, a professional. You know, there's all these other, there's LegalZoom, there's online documents. You can go through ways of getting your estate plan together without paying the cost of an attorney. And those might be the only options for some people. But what we're talking about, the strategy of setting up this trust to pre-fund the probate cost, or even setting up a trust and doing a pour over will, which allows you to really make sure that if there's any assets that haven't been transferred over to the trust, to have that be done immediately so that you can hopefully avoid the probate to the extent possible. Do you talk about those strategies?
Absolutely. Absolutely.
Okay.
Yes.
And now the other option is, if you have someone like in the case I had talked to you about, my brother, who unfortunately passed away in April of 2020. What his estate entailed was all of his bank accounts and life insurance and assets of things of value had his children identified as beneficiaries. So all of his assets and things of value was transferred to individuals, and it wasn't part of his estate and probatable. The only thing that really hit his estate was all of his debts. And so when we looked at the value of his estate, it wasn't worth the cost of probating it, given that all of his valuable assets were already transferred to his beneficiaries. So we just kind of, how do you define that? We just let it go, I guess, right?
Yeah. That's why the first thing we do is information gathering. And in that case with your brother, you had to give us enough information for us to be able to come up with some type of practical situation, because at that time we were in a, I mean, that happened right as the shutdown was taking place with
Right.
COVID. And trying to get access to things was almost impossible. So we need to try to get a profile first in our information gathering on what is the probate assets, if any, because if there are no probate assets, then there is no need for probate.
Right.
And then sometimes it's, okay, they're probate assets, but what is the value relative to the cost? And
Right.
so if you got probate assets of $500 and the cost is $5,000, well, that's kind of a no-brainer business decision.
Right. Right.
Unless,
so that's important.
the sentimental value is, outweighs the economic value.
Exactly. And then there's two other documents that that I found out in the process to avoid probate. It was the DMV affidavit of heirship, which is a way of transferring title of a vehicle to the beneficiaries without having to go through the probate process, as well as what's called the TOD for real estate. Let me see, what was the term of that? Oh, the Texas TOD deed form, right?
Yes. If in terms of the transfer on death deed, if I own a piece of real estate and I want to just transfer that piece of real estate at the time of my death to you, Clifton, I can sign a transfer on death deed that designates you as the beneficiary of that piece of real estate at the time of my death, and that can bypass probate as well. But be careful, because if you got situations with liens on properties and other complexities, if you're talking about community property and things of that nature, be real careful with some of these, what people think are simpler solutions. One of my favorite is, some people think you can do anything in probate to avoid probate with an affidavit of heirship. That is not the case. There are lots of things that can't happen just using an affidavit of heirship.
Okay. And then another way of mitigating the probate costs is there's a process of there's a small estate affidavit, right? So talk a little bit about that.
And in my practice, I have found this to be more of a theoretical possible solution than a practical solution. The estate has to be of a certain size, and there's certain very tight criteria. That's number one. But that affidavit has to be filed with the court. And probate judges tend to hate them because they typically are not done correctly by a non-attorney, or even a lot of attorneys who don't practice in this area enough. And so you wind up still having to go through a court process with that. So yes, it's theoretically out there. I have not found it as useful as I think it could be, maybe with some changes in the law.
So what I found too is that in order to complete one, you have to know a lot about the value and the debts of the estate, of which, if you haven't been appointed as the executor or the agent or whatever, it's hard for you to get to. Right? So
that's a big part of the problem. Okay. Yeah. And it's made worse in this day and age by our technology, because there are now generations of us whose whole life is on a device. And so you could have access to the home or the apartment or whatever, and you wouldn't find a single piece of paper. There'd be a device, phone, laptop, or whatever, and you don't have the password.
Right, right.
And you can't get into that device without a court order.
Well, here's what I want to do. There's 4 things I want to talk about before we kind of come to summarizing this. Number 1 is because of what you just said, because everything is now in the cloud, and at some point we may become incapacitated before we pass away. It is much more important to be organized so that if you're not able to come home one day and do what you're currently doing to keep current with your bills, that you've got some orderly filing system where somebody can come in and see where all of your bills are, how, your bank accounts, your debt obligations, what's your cash flow like, your life insurance policies, and then what are your passwords to different accounts if you're handling everything online, right?
Yeah.
You don't get any statement mailed to you anymore. Everything's online. And when you go to it, you get a code sent to your phone, and your phone has a facial ID. You can't, it's a mess, right?
Yes.
So part of the process, and do you help your clients step through a structured way of organizing those type of documents so that somebody can come in and at least pick up without too much of a hitch in the giddy up?
Well, there are 2 pieces to the advice that we have to give clients. One is, and usually the thing they're most focused on is getting the estate planning documents done. Okay, so that's phase 1. Phase 2, which I'm really trying to encourage people on, is get the administration done ahead of time and have a plan of administration. So it's great to have the will, the trust, and all these great legal documents signed up. That's great. But the glue that will bind all this stuff together after you're gone will be a real good thought out plan of administration that deals with a lot of these practical issues, like where are the doggone passwords? Who has them? Where are the documents? Are they locked in a safe or a safe deposit box? Who has access to that? That's the plan of administration. And I'm trying to get people to go to that second step as well.
Yeah, so here's some other statistics along those lines of how people are not willing to talk about this stuff. 30% of Americans don't know if their parents have a will. 40% of Americans don't know what's in their parents' will. And so when you look at the amount of assets that are being transferred by the estate, there's a lack of having a conversation about this process, and to your point, the administration of it. And so that's another thing I would encourage people to do from watching this program, is just begin to have a conversation with your parents and also with your children. And one of the ways I believe to engage the conversation with your parents, instead of asking them about their business, is share with them your business. Let them know what you have in order. These are the documents that you put in place. These are the agents and the executors that you are handling, that's handling your stuff. So you're sharing your information before you ask them to share their personal information. But do you find that to be difficult with some of your clients, again, talking amongst family members?
Oh, absolutely. What I try to stress to my clients is this: I know the law. I know the facts as you give them to me. What I don't know are your family dynamics. And you need to be very straight with me about how that works or does not work, because I can craft a beautiful estate plan that completely falls apart because it's completely inappropriate for your family dynamics. And those are the hard conversations that I wind up having with clients, being straight with me about what are the real family dynamics, not the, stuff you want, the idealized stuff, but the real stuff. Who are the players? Who are the people? How they connect to each other or don't? and how do we navigate through that to get to the result that you want to get to.
And I'll just tell you, there might be some low-cost ways of getting that done through these online programs or downloading files and doing them yourself, but you missed that aspect of it. Not only might you be putting the documents together inappropriately for your jurisdiction, but you're not having the conversation with an attorney like yourself to make sure the family dynamics is discussed, and you're crafting the documents with that awareness. That being said, what can someone expect to pay to get their will and their other estate planning documents done? I know it's based on a lot of complexity and there's a wide range, but what have you found the range to be, the minimum in using a professional to the highest that it's been?
Okay. We start every relationship with a consultation, and we have a flat consultation fee for the vast majority of things. That's $225. And for $225, what we do is we gather all this information, and then we have a consultation with you after we reviewed it all, because we understand your property, your assets, we understand the debts, we understand something about the family relationships. And then we have this type of counseling conversation about, given your goals, what your various options are. And we price things based on those options that we recommend. We bill at $300 an hour, okay? And so at a minimum, if you're using us to do an estate plan, at a minimum, you're going to be looking at between $1,500 and $2,500 at a minimum.
And what I've seen basically in the state of Texas, that's like the range. It could be anywhere from $250 to $2,500, but then based on the complexity of your estate, it could be even more than that. And so what's really important is to go to an attorney initially. And the other question I have is for people who don't have a Rolodex where they've got an attorney in their phone, where do they go? So my advice to people would be to check with your friends first to see if they have an attorney that they would recommend, or even if you have a financial advisor, which is who I encourage people to have financial professionals. So whether they're financial advisors, insurance agents, tax professionals, ask professionals if they can refer you to an attorney. And outside of that, are there any legal organizations that you would recommend to have somebody go and contact if they want to talk to the estate planning attorney?
Well, first, I'm going to recommend that they call us at Walker and Chambers. so that's number one. So let me put a plug in for Walker and Chambers, and you can call us at 214-339-1490. Email address kw@walkerchambers.com. So that's number one. Beyond us, there are a number of organizations of attorneys that you can go to. One is the Jail Turner Legal Association. You can find their contact information online. The Dallas Bar Association, if you're in Dallas, you can find their contact information online, or the Texas State Bar Association. All of them have referral sources based on areas of practice. And so I have obviously a bias towards the bar associations as referral sources.
And then also, since we are global, in addition to checking with your city bar association and then the state bar association, there's also some national organizations like the American College of Trust and Estate Council, and then the National Association of Estate Planners and Council as well. And then they have chapters, I guess, or affiliates in different cities. So those are more national organizations, since we might be someone might be viewing us who are not in the state of Texas or Dallas.
Yes, and so let me throw two more in: the National Bar Association and the American Bar Association.
Got it. So definitely those resources. So your contact information will be one of the links below the YouTube in the description section, as well as some of these other national organizations that we talked about. So we talked about the cost, Where do you go? How do you get connected to the resources? Also, there's LegalZoom, and there's, what's it called? Nolo, Quicken, Willmaker, and Trust. So there's all these other places you can go, but I really will encourage someone to at least pay for the consultation with an attorney. How do you deal with people who come to you and they say, well, I can download a form from online or go to these other, lower cost legal services versus sitting down with an attorney like yourself for at least the initial consultation? What do you recommend people who are looking at those options?
It's real simple. The real question is, are you looking to buy a form or are you looking to buy professional advice? Okay. I can go into any pharmacy and buy lots of medication. That doesn't mean I can diagnose myself. That's why I go to a physician. If I need a diagnosis, I'm going to a physician. If I'm comfortable with my self-diagnosis, I go to a pharmacy and I pick up something off the shelf and hope it works. What are you really trying to buy? If you're trying to get professional advice, you need a professional. If you're just trying to get some forms to fill out, then you can get virtually any type of legal form on the internet. The problem is, it's kind of like, doing brain surgery on yourself. I probably can go and get a medical kit from somewhere, but that doesn't make me a surgeon. And the challenge that a lot of people have is they're inputting information into a system that cannot possibly anticipate everybody's specific situation. And you're making interpretations of what questions mean, and you may be misinterpreting. And so it's a lot, sometimes it's garbage in and garbage out.
Okay.
Is it better than nothing? In some cases, yes, it is better than nothing. But be careful, you get what you pay for.
That's true.
At the end of the day, you're not buying professional advice, you're buying a set of basically forms.
So are there any resources for people who are low to moderate income and they really can't afford the full price of an attorney? Are there pro bono services or very discounted services based on income or the size of the estate that you would recommend somebody to if they couldn't afford your services?
If it's somebody who needs pro bono services, those bar associations, that's the place to go for pro bono services.
There you go.
If it's just low or modest cost, then I recommend at least pay for a consultation with an attorney who practices in this area, because worst case, they may be able to give you, one, they can assess what your actual needs are.
Gotcha.
And two, they can give you a roadmap to get there. All right. And so at least you're on the right road. And
so
you're
definitely
not
check out the bar association.
Yeah.
Yeah. So definitely check out the bar associations for any pro bono or no cost or low cost services. You can at least afford a consultation with an attorney. Sometimes consultations are at no cost, but a real thorough one will have some fee associated with it because you're asking the attorney to actually put their work and effort involved in assessing your estate to give you the quality recommendation. We can go into a lot more detail, but we're not right now, because when you look at estate planning and sizes of estates, you can look at the different types of trust that can be established, whether it's a special needs trust for someone who has a child that requires special needs and they don't want to affect their child's eligibility for state benefits in the event that they get an influx of cash. Or you can look at a testamentary trust, which is part of the will. You can also look at a charitable remainder trust for people who are very wealthy and they want to look at some tax benefits in creating trust. So I say all of these not to say that we're going to go through them, but to encourage you, if you're watching, to really sit down with a professional and hear about those different strategies for people who have a very high value estate and they want to make sure it's protected and it goes to their beneficiaries in a very efficient, smooth way. As we kind of wrap this up though, Kenneth, what will be your final comments to really encourage people during, October Estate Planning Awareness Month or any month to really seek out services of an attorney or of a professional to get their estate in order?
A couple of things, Clifton. One is estate planning involves you, but it's not necessarily about you. It has more to do with the people you leave behind, because after you're gone, it doesn't matter what's in your estate plan. But for the people that you care about, it can matter tremendously what's in the estate plan. It matters for you in that situation of incapacity. So all of us need to think about, but for the grace of God, there go I, in terms of being incapacitated. And just like I have life insurance and other types of health insurance and things like that, I better have some hedge against finding myself incapacitated and I haven't taken care of that business to designate who does what. The other thing that I'd like to say, Clifton, is we're doing a couple of new things in our practice. I haven't had a chance to share with you, but estate planning for me is about more than just the stuff, the property and the money. It's also about your life and your legacy, not just in material terms. And so I'm working with my daughter, who is a writer and has her own business. It's called A Little More Truth, LLC. We're going to collaborate and start trying to create legacy narratives for our estate planning clients so that they can transfer to future generations their life stories, their wisdom, their experiences, their values, and you can pass that on from generation to generation. And then the other thing that is new that we're working on is creating trust to build intergenerational wealth. How do you do that with families with, not wealthy families, but families who have something that they can pass on to future generations on an extended family basis? Like a lot of times there's been heirship property in the family for generations. Nobody has taken the time to consolidate it all and make sure it stays in the family. How do you do things like that? And so we're very excited about creating those types of trusts and helping people build that intergenerational wealth as well.
Man, we can talk all day, Kenneth, you know about this, right? But I would just tell you, I appreciate you more than words can express, for you being a part of our Empower series for multiple years and pouring into us like you have with your knowledge, your expertise, and really being a resource. What we hope to accomplish in all of our Empower series programs are giving you hope that you can achieve whatever you envision, inspiring you to take action. So in this case, we want to inspire you to continue your research, continue to reach out and find a professional through either these organizations, through your friends and family, or by contacting Kenneth. And so inspire you to take action. This program hopefully educated you and shared with you some information that you didn't already know, but then more importantly, connecting you to resources. We have a belief here at the Empower series that whatever you need to take that next step towards your goal is within your reach. So it could be looking at this program or sharing this with somebody. It could be following through reaching one of the organizations in the link below. It could be just reaching out to Kenneth and setting that initial consultation. So whatever step that is required for you to take that next, to take that progressive move towards your goal is available for you. And so that's what we hope to do with the Empower series, and you are a part of that. So Kenneth, thank you again. Thank Gail for keeping you organized. I want to find out more about your daughter's business, because I like that. One of the things that we just did in my family, my aunt wrote a book about my uncle.
Yes.
And that's one way of keeping that legacy on and passing it on. So I would love to meet with you and your daughter and see what you're doing, and maybe have her on the Empower series to talk about how we can help the community pass on that legacy. And I want to thank you for spending your time with the Empower series, because you are the Empower series. Thank Comerica Bank for being a long-term supporter of the Empower series, AE Media Group, and as I said before, our viewers in the United States and around the world. So until we meet again, I want you to take action on what we talked about, number one, and I want you to be inspired to thrive. Thank you for watching our Empower Series YouTube video. I really hope you enjoyed it. Remember to hit the subscribe button below, as well as the little button to be notified the next time we upload our video. Until then, stay connected with us on social media, Facebook, Twitter, Instagram, whatever your social media flavor is. Inspire the world to thrive. See you soon.